On se donne 5 minutes si vous voulez bien. I mean, we'll start in 5 minutes if that works, just to make sure everything's okay on the transmission side. I don't know how many people are online, but let's make sure they can hear what we have to say, and we have great panelists today. Okay, are we good? Guillaume, we're good? Super. So hello and welcome. We're delighted to have you here, and we have amazing panelists. As you can see, I am not Julie Zoria. My partner is like all of us here, a lawyer, and she has an emergency she needs to deal with. So she has asked me to step in. She'll be here in a half hour or so, but we didn't want to delay the start of our discussion. So I hope you will be forgiving if I stumble on words or I am completely out of tune with the discussion. So the panel today, Fraus omnia corrumpit, really, addresses where the Paris Court of Appeal stands when it comes to enforcement of awards dealing with allegations of corruption. It is at the intersection of several practices of the firm, an issue complex, evolving, dealing with arbitration, corruption, French international public policy. The discussion today will focus on recent case law, including the Verda and Cardinal matters, examining how the Paris courts balance the fight against corruption on the one hand, and corruption and fraud, with the finality of the arbitral awards. And it's been, for us, I think, the third Paris Arbitration Week. We have organized a panel on related issues. So it's really a point of focus for us here at the firm. So our speakers today, Athina, Selma, Maxime, and Jean. Thank you so much for being here today. Athina is an international arbitrator based in Paris. You are a Greek national, dual qualified lawyer registered both in Athens and Paris. You've spent over 15 years in the arbitration departments of leading international law firms and launched your own practice in 2022. You have extensive experience in Africa-related matters, state and state entities across numerous industries.
I confirm.
Oof. So good so far. Selma? Selma is a senior director and expert at the expert services practice of Kroll. She's based in Paris. She acts as an expert witness and provides support to litigation and international arbitration matters. Her areas of expertise lie in damage assessment, financial auditing, and forensic services. And she regularly acts as financial expert before French jurisdictions on domestic litigation case. And Selma, your work covers a variety of sectors as well. You confirm. Jean is a director and legal advisor at Société Générale in La Défense just by Paris. He has accompanied companies in their disputes for over 15 years, both as an outside counsel in international law firms and in-house. You have a strong focus on financial sector. You've built an experience in dispute resolution through regulatory investigations, cross-border litigation, class actions, and international arbitrations. You are a lawyer, both qualified in Paris and New York. Maxime Desplats. So hopefully Maxime is my partner, so I won't get it wrong. Maxime is a partner at Navacelle. He practices business litigation, in particular in international arbitration and commercial litigation in France and abroad, focusing also on the OADA region. He has worked for over 15 years in international law firms, Debevoise and Plimpton, where we were associates together a few years ago, and DLA Piper. He has been involved in a number of complex litigation and arbitration cases with high financial or strategic stakes, notably in the energy, constructions, and telecom sectors. He also appears in front of French courts on mostly commercial disputes, but also arbitration-related disputes, exequatur, set-aside proceedings, and so on. Before I start, I want to thank our associate, Alban Fèvre, who has been instrumental on putting this together. And with no further ado, I will maybe give you a brief introduction before I pass over the mic. So, Fraus, omnia, corrumpit is a very strong principle, obviously, that suggests that everything should be voided in the event of corruption. And we've seen the case law over the past year in Paris evolve, and we're going to focus today on a more nuanced approach than in the past on behalf of the Court of Appeals, and which basically has led the court to treat corruption rather than an automatically contaminating the entire contractual framework and the award. They have focused on isolating specific effects of corruption and assessing whether enforcement in France would concretely allow a party to benefit from it or not. And we have decided to structure our discussion into 4 parts. And I'm just going to go through those 4 parts and then ask Jean to say a few words about the in-house perspective, which is always very interesting. The first part is going to be the scope of international public policy review by French courts in light of this recent case law, and Maxime is going to take the lead there. The arbitrator's role when faced with indicia of corruption, and Athina is going to take the lead there. We will then go to the contribution of expert evidence in the neutralization process, and Selma, that will be your lead. And we will finish with Jean on the predictability of awards and risk of set-aside. So, How does one define what has been tainted, and what does that mean in terms of predictability? Jean.
Thank you very much.
I have to say to everyone, so for people online, we have to speak in the mic, and Guillaume, you have the right to wave if it doesn't work.
Thank you very much, Stéphane, for inviting Société Générale to this panel. The preparation work that you put into organizing this event is impressive, and you're a fantastic host. Thank you very much. As noted by Stéphane, I work in the litigation and investigation department of Société Générale, where we handle at group level all major litigation risks, mostly in a defense role. Set aside some exceptions, we mostly ask, our team rarely acts as a claimant. That's just for the... I will try to bring to this panel the view of an arbitration user from the finance sector and present what parties are looking for in arbitration and how this new string of case law might affect arbitration user strategy at all stages of a deal. When we read Bellocon, Sorelec, Averda, and now Cardno, our first reaction as in-house counsel is not necessarily legal, but it's operational. What do we do differently on Monday morning? If I'm presented with a project in a country ranked 130 by Transparency International and the other party is a state, how these recent matters will affect my take on this project. Here are 5 client messages following the chronology of a deal that we in-house lawyers can take away. First of all, upstream. We need to think about arbitration from day one. Why this changed? Since Bellocon and especially Sorelec, Paris courts accept a substantive, evidence-driven review of awards when international public policy, notably corruption, is credibly engaged. That means a favorable award is only as strong as the underlying operation when stress-tested against corruption indicators. What Cardno adds. The court dismissed an annulment brought by the Central Bank of Iraq against an ICC award in favor of Cardno, after the state had largely sat out the arbitration and later invoked fraud and procedural unfairness. The court underlined a core principle: raise what you know when you know it. The judge will check whether alleged irregularities could and should have been advanced during the arbitration, and whether the tribunal reasoned on any late reopening request. What are the client takeaways? First of all, I think as client we need to front load the facts and make the tribunal engage with sensitive issues. 2, a late pivot will likely be treated as waived or insufficient. And 3, arbitration seat in Paris protects robust, well-reasoned awards. The choice of a seat has become increasingly an investment committee decision. Paris implies potential intense scrutiny where public policy is credibly at play. London traditionally shows more deference to the tribunal. Neither is better, but each changes the risk and the price model should be decided with the arbitration stress test in mind. What is this stress test? First, secure negotiation traceability. Make sure you keep the minutes, the emails, and the approvals. Make sure the state party procedures are respected, written confirmation of approvals. Make sure the economic balance is defensible. See whether you have the benchmarks and the fairness notes. And make sure the country risk context is mapped and mitigated. Strong KYC analysis, risk cartography. This is precisely where French courts have looked for red flags and where an award can become vulnerable if the record is thin. 2, still upstream, compliance is now our strongest exhibit. For years, compliance has been seen, internally at least, as a cost. We have to abide with Sapin 2, FCPA, UK Bribery Act. Today, every euro spent in traceability and due diligence constitutes evidence and protects the future award. The judge's red flag, opaque flows, lack of negotiation records, imbalanced concessions, governance shortcuts, mirror the compliance officer's checklist. Well-governed processes become evidence at the annulment stage. From a banking angle, in structured or project finance, the award that protects the debtor or the collateral value is part of the legal security package. If that award is exposed, it can become unbankable. So I think from this second prong, we can say that compliance has moved from a cost center to value protection. 3, during the arbitration, the award is not the finish line. We have to assume an annulment round. Strategy, budget, and evidence preservation should anticipate a post-award challenge with timelines of 24 to 36 months and a quasi-trial on public policy with new evidence possible. The key takeaway here is to make the tribunal engage with corruption inside the award. Paris, as a seat, will respect tribunals that squarely address credible corruption allegations and reason their choices, including a reasoned refusal to reopen the matter. That is the connective tissue between Cardno, which is upholding a tribunal that explained why you would not reopen later the case, and Averda, which is endorsing a tribunal that investigated and quantified execution stage irregularities. The operational steps during arbitration: preserve the evidence in real time, don't wait for the court round, force the issue, if corruption is in the atmosphere, get the tribunal to inquire and reason. Silence in the award invites risk. And finally, budget for a second battle, annulment, including fact development that may continue post-award. 4, during the arbitration, controlled transparency can save the essentials. Averda contre Gabon is the most pragmatic development for operators, where corruption taints the execution, not the formation of the contract. The tribunal may neutralize the irregular portion and preserve compensation for legitimate performance, and Paris as a seat will uphold it. The signal is clear. Transparency is rewarded, denial is punished. Client playbook: if irregularity exists, pursue controlled transparency. Acknowledge, isolate, quantify. Offer the tribunal a methodology, including the opponents, if it is sound, to calculate the reductions. Keep formation stage clean. If the contract was procured by corruption, neutralization won't save the contract, of course. And 5, downstream, a fragile award is worth less. So a fragile award is worth less. From the third-party funding perspective, where we might have recourse to this as clients, funders will likely price the annulment for corruption, funders will likely price the annulment for corruption path explicitly, and the exposure may increase with the choice of the seat, the sector, and red flag profiles. Regarding credit insurance and political risk, coverage terms move with the enforcement risk map. Credit insurance questionnaires for banks include questions such as whether the bank has been found guilty of having committed an act of bribery by a public arbitration ruling. These facts are highly scrutinized and have an impact on potential coverage for the bank.
Thank you so much, Jean. This is tremendously insightful, and I'm just impressed by the detail in which you go when you try and describe what goes through an in-house lawyer's mind when it comes to these issues. And I think also it's very topical as we are in the 10th year of Sapin 2, and to see the contribution to Sapin 2 to arbitration and the validity of the award. So thank you so much for that. And maybe I'm going to go to Maxime now on maybe a more sort of in-depth analysis of this recent case law for our sort of next installment.
Sure, thank you. Yes, I think the landscape in France changed quite drastically. If we take a few steps back, I remember that in this very room a few years ago, there was a panel discussing the Sorelec cases, which appalled a lot of people from the international arbitration community. Just as a reminder, in the Sorelec cases, you had an arbitration going on, then you had an award in favor of the creditor, obviously, and after there was a setting aside proceedings before the Paris courts. And before those Paris courts, you had the debtor who said, well, Mr. Judge, you should annul the award because the contract is tainted by corruption. And that was an issue that was never discussed before the arbitrators. So the first reaction of the creditor was, well, you never discussed that, you never disclosed that, so we shouldn't even be mentioning it, we shouldn't even be talking about it. That didn't go that way, though. The Paris court dismissed the argument and set aside the award on the basis of corruption, even though that had never been discussed before, and on the basis of indicias of corruption only. That was the status of case law 5 or 6 years ago, and it was upheld by the French Supreme Court, la Cour de Cassation. And if you think about it, that was really harsh on creditors. You know, well, first of all, they had never the opportunity to challenge that before an arbitrator, the forum that they had initially chosen. And since then, we can see that there's been a little shift. I wouldn't say a major shift, but a little shift, whereby judges now French judges try to fine-tune the analysis. And in this respect, the Averda case, which I'm sure we're going to come back on, is very insightful. Why is that? It's because, well, as it's been already mentioned, so it's a case between Averda, cleaning company, and various public entities in Gabon. And what happened is that the arbitrators found that there was some part of the enforcement of the contract that was tainted by corruption, but not its formation and not part of the performance. And so what the arbitrators did is that they decided that the creditor, while the cleaning company could, even though there were some clear indicias of corruption according to the arbitrators, they could nonetheless make an award on damages on the part of the services that were not tainted by corruption. Obviously, Gabon was not very happy about that result, so they challenged that award before the French courts, before the Paris courts, as Paris was the seat of the arbitration. And the judge actually upheld the award because they found that what matters is really to ensure that the enforcement of an award does not go against public policy and does not, and how it translates here, well, you want to make sure that no one's going to benefit from corruption practices. And in that very case, they said, well, the arbitrators did a good job. They neutralized the effects of corruption, therefore I have nothing to say, so I'm going to upheld this award and I'm going to dismiss the setting aside challenge. So I think this is the first decision which is so clear in that direction that we have on the record to the best of our knowledge. And so we can probably see this as a shift. And we can see this as a shift, especially if we look at other decisions, other recent decisions that took place over the last 12 months. And we've been referring to Carnot. And I think this is worth mentioning as well, because Carnot goes in the same direction. So the Carnot decision, just in a nutshell, and not to take too much of your time, so we have more room for discussion and debate afterwards. In the Carnot decision, what happened is that you have the Central Bank of Iraq, who decides to contract with a company called Carnot for the construction of its headquarters in Baghdad. Well, so the Carnot worked and didn't get paid, so obviously it launched an arbitration. And during the arbitration, the Central Bank of Iraq did not appear until the very end of the arbitration, whereby suddenly they appear and they say, well, you know, there's been some fraud here. And the arbitrators say, wait, you could have, I've been asking you for months and months to appear before me. You never answered. So now it's time, and then, so this is clearly a delaying tactic. So I'm not going to hear you, and I render my award. Challenge afterwards, again before the Paris courts, as Paris was the seat of arbitration. And what happened is that the Central Bank of Iraq said, you know, I can raise this at this stage before the Paris Court of Appeal according to recent case law. And Carnot replied, well, no, you cannot do that according to Article 1466 of the French Civil Code of Procedure. And so there was a debate as to whether the Central Bank of Iraq could raise new arguments at that very, very late stage of the proceedings before the Court of Appeal. To make a long story short, the French judge said, well, in that case, normally it's true that you can raise a breach of international public policy at whatever stages of the proceedings because it's so important that it doesn't matter whether you raise that before or not. But here they said it depends what we're really talking about, which kind of international public order we're dealing with. And they're saying if it's a fraud that deals with private interest, then it's a bit different, and therefore you should have raised that a long time ago. And so the challenge was dismissed. Again, this goes in favor of arbitration. Well, at least that's the way I see it. Maybe we can debate that. So those are two decisions which shows a kind of shift favorable to arbitration. And then a third decision maybe I would like to quickly mention is the very recent AVZI against GCM order that was made by the investigative magistrate, well, Conseiller de la mise en état, I'll say it in French, because otherwise I'm afraid not to use the exact word in English. And so, so in a nutshell, what happened is that you had, again, an arbitration between AVZI and JCM. AVZI was saying the arbitrator does not have jurisdiction. And the reason why it doesn't have jurisdiction is because JCM is relying on an arbitration agreement which is in the bylaws. The problem is that to become a partner in that company, GCM bought shares, and AVZI was saying you bought those shares without first through corruption and also in breach of preemption right. And so there's been a whole debate before the arbitrator to check whether that arbitrator had jurisdiction or not. And the arbitrator at the end of the day said, well, I do not have jurisdiction, but not for reasons of corruption, not for reasons of preemption right. I'm not going to look at this just because, and because there was some kind of formal process that had not been complied with. So no need to get into the details. The important point here is that the arbitrator said, I don't have jurisdiction, and I'm not going to look at the corruption allegations that were made. Okay, then there is a challenge from GCM before the Paris courts, before the Paris Court of Appeal again, and before the judges, AVZI said, well, you should have a look at plenty of documents and hear some witnesses, and you'll see that JCM got into this contract through got into the partnership of this company through corruption. And before the judge said, no, I'm not going to look at this. I'm not interested in this because the arbitrator himself said that he was not interested in corruption allegations. Okay, so again, this is a kind of decision where you see that the will of the parties to have everything being arbitrated is fully respected by the judge. And again, this shift is in favor, well, that's the way I see it again, in favor of a pro-arbitration stance. So so if to come back to what I was saying earlier, it really seems like a change from the very discussion that happened in this room 3 or 4 years ago. And I think we'll be able to talk about other decisions, but I think I've already talked enough right now, so I'm going to give the floor back to Stéphane. Thanks.
Thank you so much, Maxime. Athina, I really want to know. I'll do the question I want, and then I'll read the script, right?
I'll give the answer I want.
Yeah, that's fair enough. Fair enough. When you've finished your award, do you give it like a final read, thinking, how is the Court of Appeal going to read this? Okay, thank you. It has a video, so we see you nodding. But anyway, so you want to say? Yeah. But yeah, for the you know, I mean, I guess the overall overreaching question is, you know, what's your role as an arbitrator when you're faced with, you know, indicia of corruption? And you've already answered my first one, but you can maybe elaborate.
Sorry for the transcript and for people who have joined online. Yes, I think that's a duty of the arbitrator to render the award annulment proof. And I am a member of the ICC court, so we review the awards to make sure that they are annulment proof, and I mean, it kind of gets to become a second nature. What does an arbitrator, what an arbitrator should do when faced with, you said allegations or indicia? Or indications, no, red flags of corruption. The arbitrator may be faced with red flags of corruption without allegations of corruption, right? And this often happens in practice. 30 years ago or 20 years ago, the favored approach in many international cases is, I don't see it. The standard of proof of corruption is as high, so if it's not proven, then there is no corruption, or at least I'm not in a position to make a relevant finding to that effect. And the trend has changed very significantly in the recent years. Not only in France, where in any event we consider that we are in our legal theory is such that we consider that the arbitrator has the right to investigate, has the duty to investigate and find the evidence of what has happened and try to find the truth behind the arguments of the parties. But even in common law countries where we are opting for adversarial proceedings, and the principle is the arbitrator is there to examine what the parties have said. I mean, if you haven't heard that already, it's useful to look at the PNID decision in the UK, where exactly the judge mentioned the duty of curiosity of the arbitrator. It's not just what the parties have said, it's also for the arbitrator to investigate. So this is the point one, that it's a take away. Another element that is of importance is to what extent what is the impact of corruption? Where do we find the corruption? Is the corruption, has the corruption taken place at the time of the conclusion of the contract? Is the contract itself stained by corruption? In that case, in French law, we consider that the contract is ab initio null and void and should not be given effect to. I think that in comparative law, that's quite a common approach. Not necessarily the effect, the result of that approach. The contract has been entered into by corruption. Does it mean that I can come today and say, you know, all the payments that the parties have made need to be returned to each other, and therefore we need to be placed in the position that we would have been had there been no contract? That's the French approach, more or less. Or do we say, no, you know what, you entered into a contract by corruption, clean hands doctrine, you cannot come and seek my help as an arbitrator to do whatever, go back home. That's a different approach, right? Even if we are still discussing with contracts entered into by corruption. That's another category. Then, that's the first category. the other possibility is that there has been corruption at some stage in the execution of the contract, in the performance of the contract, but not at the time of its conclusion. And that is the Averda case that you very well summarized. In that contract, none of the parties said there was a corruption at the conclusion of the contract. What the parties said is that at some point, for part of the contract, there were like payments, commissions paid to the authorities. The invoices were exaggerated so as to cover for these commissions, presumably. So it came at some stage at the contractual execution. What could you do at that stage? And there I think that we have more discretion. If we cannot distinguish between what relates to corruption, what does not relate to corruption, perhaps an arbitrator will have no other option but invalidate, consider that all this is so enticed by corruption that it cannot be given effect to. In the Averda case, the arbitrator said, let us examine exactly what is the result, what are the overpayments due to corruption, and find and limit the damages that we will pay to, that we will grant to one of the parties. In that case, it was possible. It was possible because the arbitrator invited both parties, the party claiming corruption and the party saying that no, there has been no corruption. And they said to the party saying that there has been no corruption, that if you, as an alternative position, tell me what would have been the possible extent of corruption. And what the arbitrator did was to take the highest percentage proposed by the parties and apply as a percentage reduction to the amount. So that's the second category, right? And then there is the third category, indicia of corruption, relating to the actions of the parties, but not concerning the contract on the basis of which the arbitrator is called to decide something. And this is something, I have seen it in the past. I have had claims like that where you see a dodgy behavior, if you want, right? And there is a question as to what extent do I need to investigate into that question. But at the end of the day, if this is something that is, it is something that perhaps can give you some hints on the way that one of the parties acts and does business in general, but does not have any effect on the specific contract that you deal with, then you are not supposed to be handling, to be taking any decision on the basis of that, in terms of damages calculation or something like that. So you see that the role of the arbitrator varies on the basis of, there is not one size fits all, this is what we do when there are corruption allegations. Is there, perhaps we can continue discussing, but is it fine if I stop here? Sure. And then we can have another discussion on...
that makes great sense.
Okay.
So if you mind, maybe we can go to you, Selma, if you don't mind, and maybe elaborate on the contribution of expert evidence in the neutralization process, and maybe you can share some experience there.
Sure.
I think. Merci. I do think that experts, specifically in the case of Averda, had a very crucial role, because I have a hard time imagining the arbitrator deciding on a discount rate by themselves. In the Averda case, it's quite interesting to see in the decision of the Paris Court Appeal which quotes the arbitral judgment. It says that the methodology has been agreed, actually, by both experts. Everyone was in line for the same methodology. But Averda proposed a discount rate of 17%, whereas the state of Gabon said it should be 33 or 35%. So for me, this is quite interesting, because usually experts never, or in a very few cases, align on the methodology, and even less on the result. So this is quite important here, and I think it was very helpful for the tribunal, because he could, have something to stick to. I do think this was very crucial in this case. We don't have enough information on the way the expert proceeded exactly. We only know that they compared actual quantities of actual and estimated quantities of services. They relied on testimonies also on what has been performed or not. So it seems that the experts relied on a series of information to determine what invoice has been really performed, correspond to service really performed and which not. We don't have much information on that. But yeah, I do think, I mean, I would think that the outcome would have been very different if the expert wouldn't have aligned on some, common ground in terms of quantification.
And do you have any sort of understanding as to what the, what got the experts to agree on the same methodology? Is that something that you encounter, sort of dealing with, opposing experts? I don't know if you can call them opposing experts, but on methodology, is that sort of the trick? Once you've done that up front, then it's the dice are thrown and you have to accept the result?
Well, it doesn't happen often that we agree on the methodology. Usually we use different methodologies and we have different instructions, or even when we have the same instruction, in damages, we have a lot of methodology like DCF multiples when we have to quantify damages. So usually you are confronted with an expert using something else, responding to another question. So this is why I say in Averda, it's something to have them agree on the methodology. And then even when we agree on the methodology, sometimes you take just slightly different assumption and the result is completely different. So yeah, it strikes me here that they seem to have aligned on the methodology and to have followed the same type of calculation.
Yes, just a comment on that. That what we see also in practice is that sometimes the arbitrators will force the experts to follow a common methodology. And again, we have not been working on the Averda case, so the most that we can do is double guessing. So we will not enter into that exercise. But it does happen that arbitrators will ask both experts and say, okay, now adopt the methodology of your friend here and tell us what the result would be were you to adopt that methodology. And this would have been an interesting exercise that the tribunal could invite the experts to do in such a case. No, what do you think?
What is mysterious to me is when I read the decision of the Paris Court of Appeal, they say that the methodology was proposed by Gabon, actually. No, by Averda. I wouldn't have expected that. I would have expected, Averda to say no. I mean, all my invoices have to be paid, and that's all.
Possibly it could have been, possibly it could have. Why not? But possibly it could have been again as an alternative.
Probably, yeah.
On the invitation of
yes.
the tribunal. Okay. You say that there is no corruption.
What if?
Say that I
yes.
come to the opposite conclusion. Would you accept the methodology of Gabon as a matter of principle? Yes, okay, then calculate. No, then what would be your methodology? Okay, then supposing I were to follow that methodology, how would you apply it?
Yeah, probably. I think that's probably what happened, actually, because I cannot imagine, the expert of the claimant proposing just ex nihilo methodology to say, okay, maybe there's corruption and here is the methodology. But then it's good, right? Because arbitrators sometimes just don't want to give any direction, and it's a problem for experts because sometimes we just work and we do some calculation and we don't know if this is useful for the arbitrators.
Maybe just to bounce back on this, from the Counsel's perspective, I think that must have been a terrible, terrible and very, very difficult decision to make, because I'm following you, I'm with you. I think the arbitrators must have been pretty smart. and say, well, what if we were to look at this? Imagine there is corruption. I understand that you're saying there's no corruption, but let's imagine there is. Which methodology would you implement? And here it's very tricky, because as a counsel, either you go against the tribunal and you say, well, I'm not going to get into that at all, but then you take the risk of having no damages at all, or you saying yes, and then you get the risk of limited damages only. So it must have been very difficult for a counsel, and I think they probably looked at the indicias of corruption, and they probably tried to assess the risk, and we can only second guess again, but they probably thought it was safer to enter into a discussion on methodology and try to fight hard on the amount that would have been tainted by corruption. And we see that even with the same methodology, experts are really good at disagreeing. Because on the one hand, you have 17%, and on the other hand, you got 35%, which is a significant difference between the two. But I was just wondering, as an expert, do you see this as well, first, is it a common exercise, or is it something new for the field? And probably another question, do you see this as an easy exercise? Of course, I guess it depends of the case and the facts, but I was just wondering whether it's easy for an expert to say, this is tainted by corruption, this is free of corruption, pretty easy, that goes on the left side and that goes on the right side.
Thank you, Maxime. I wouldn't say this is not, I wouldn't say this is typical, but it's not unusual neither. I mean, I have been working previously with PwC, and actually in the forensic services team, we specialize on damages, but we are also supposed to do investigation, financial investigation, work on compliance. So an expert, a forensic expert, is supposed to have several hats, actually, because, you know, the different specialties have conversion points, and it all relies on an accounting and financial background. So most of experts should be able to do some kind of investigation. Sorry, the second question was?
How do you think, well,
yeah.
it's an easy exercise for that?
No, it's not, and it's not an exact science. You need to have a series of indicia to, you know, to see testimonies, on invoices you have to check quantities, real quantities, compare them to the average you see on the market. You have to do some analytical tests, but at the end of the day, you just have a good estimation of what you think should be the, you know, but it's never exact. It's just a guess, best guess.
Sorry. No, please. I have a question, because when we... Yes, so there are indicia of corruption, as you mentioned, which are, for example, invoices which are a bit too expensive, yes. Or payments sent to non-identified accounts or third parties, or I don't know, the ministry officials participating in the deal, having become quite richer in terms of amounts spent for buying cars just after the deal is concluded. Anyway, things like that. What we often see also analysis as to whether the deal in itself made economic sense or whether it didn't, in order for either party. And we see in decisions, awards of tribunals or decisions upholding such conclusions that say that given, I don't know, the amount of initial investment and the country risk and the duration of the contract and the kind of market, the amount payable to the state or whatever was reasonable, and therefore I have no reason to believe that there was an element of corruption at the conclusion of the deal. We don't have the impression that the arbitrators often have done this exercise with the help of an expert. And I was wondering, I mean, as an expert, do you think that this would be an easy exercise to do? Or have you ever been asked to do such an exercise?
No, No, I don't. But I don't think this is an easy exercise for arbitrators, because to be able to analyze the economics of a contract, I mean, you have to be, you have to be a bit familiar with the sector, with the activity, to know what happens on the market, to have a good sense of how this works from a financial point of view. So I have never been asked to do so, but I would be very surprised to see arbitrators able to do that kind of work by themselves. I mean, you can have an idea, roughly speaking, you can feel there is something wrong, but you know, to prove it, it's something else.
So I feel that you want to take on more responsibility as an arbitrator, and you want to save the world from corruption, which is you know, really amazing. But more seriously, do you feel that there's more that could be done or that should be done by arbitrators? Should they train? They can't train in every field. They can, you know, the ICC had its, you know, red flags, and I learned about the green flags, which I thought was very dangerous. You know, it's like, oh, there's a green flag, so it's, you know, just go ahead. I mean, do you feel that there's more that can be done?
I mean, that's a philosophical question. Is there more than can be done? Yes, of course. It's an easy one. There's always more than can be done. But I think that there has been a significant a significant evolution in that regard, and that arbitrators today have tools that are available to them, which just simply did not exist 10 years ago. You mentioned the various indicia or the flags. I think that there is a development, which is also a welcome development as to what are the flags in question. And there are the general flags, no? The general nature flags, how do you call them? Which have to do, I don't know, with the corruption index of a specific economy. Now, seriously, would you be happy if your arbitrator said, well, this is a contract taking place in Gabon, so I think that it's possible that it was entered into by corruption? I mean, it's not serious, right? But there are indicia of corruption that are specific to the contract or an action of a party, and these indicia are useful, and the fact that there exist lists and lists of relevant indicia can be a useful tool for the arbitrators, I think.
So the more that can be done is actually be on the lookout for these indicia and keep an open mind, I guess.
Yes, or sorry. Asking I mean, as we said, the duty of curiosity. What is the duty of curiosity? It is to ask the parties, invite the parties to give their position on that, or if I mean, possibly in extreme circumstances, appoint an expert. And when I say extreme, I mean in cases where you cannot, you feel that you are at loss, and the case, the amount in dispute, perhaps would render such a decision a good decision in terms of the advantage of having a quick process and the advantage of going closer to the to justice or to the truth.
Thanks so much. I'd like to open to questions and comments, but maybe Jean, a question from your perspective on the impact of all we've been talking over the past hour or so on, you know, your decision as a client, or what you factor in terms of, you know, trying to get a deal, you know, accepting the risk, you know, how much of a gambler? For a banker, I hope not at all. But when it comes to arbitration, maybe you can share a few thoughts.
Thank you, Stéphane. And to go back on what you last said, Athina, I think it can be the parties', you know, role as well. If there's a smell of corruption in the air, and if you want a valid award and not go through the whole annulment stage, or have some sense of predictability, this is something to bring up during the arbitration. And then, Stéphane, to answer your question, the way things are being structured in the banking industry, or at least how it works, at Société Générale, we have the deal team that comes to us, that explain what the deal is about, and then we have 24 hours to decide on an arbitration clause that was often drafted by the opposite party, and we have to give advice on this. We, of course, within a bank, there's not just one job. We do M&A, we do sessions. We've had to get out of countries because of the recent geopolitical issues. We had to get out of Russia. We've had to sell our banks there. We've had some strategic decisions to make regarding Africa, and some sessions were made as well. All these matters, they all have different faces, they all have different incentives, and the bank has a different approach, whether it is selling a branch somewhere, or whether it is financing a deal on petrol or whatnot. So I cannot respond with one answer, but what I can say is that each time this comes to a position, this is put to a question, we of course try to assess what are the different risks posed by various applicable law. Seat, of course, seat has become a major investment decision. And when we get to decisions where the deal needs to take place, but the other party won't budge, then of course there's a risk acceptance that's inherent to any type of business conducting. But what we take away from all these decisions here is that Paris courts are pro-integrity. It rewards front-loaded diligence, reasoned tribunal work, and controlled transparency, which for operators means that the choice of the seat is a risk decision, of course. We treat compliance and documentation as evidence creation. We run the arbitration as if the Court of Appeal will read every line, and I think this is extremely important. And if there were execution stage issues, quantify and neutralize them. And I think in that respect, the Averda matter, I think, is a great progress towards making the business go. And finally, when we get into this type of projects, and this is always something that we share with the deal team, you need to price your project and monetize the award, and monetize the deal with the award's resilience in mind. Voilà.
Thank you, Jean, so much. Do we have any questions, comments from anyone in the room? If so, don't be shy. Ah, super. I have a request. Oh, yeah.
Yeah, this has mainly been about some jurisprudence or some case law that I don't know about. Could I get a list of the cases with the official citation? Or even, oh, you have it ready. You've anticipated my question, so thank you. I believe everybody would have asked for that, I think. Huh? Or maybe they took it for granted it would come.
Merci.
Thank you, Stéphane. Hello, I'm Wouter de Klerk of Legal Tree in the Netherlands. I'm glad Carnot was mentioned. I've been involved on that case with my old colleagues from DLA Piper, at least on the Dutch enforcement leg. But I have a question, maybe I can put it to Maxime, on the state of French law. And regarding a slightly different problem that the Dutch courts have been struggling with. And I'd call it the snowballing effect or snowballing corruption allegations. So what if allegations are made of corruption in the arbitration, they are investigated and they are dismissed because they are considered too vague by the arbitral tribunal to entertain. And what we often see then subsequently, if the case goes to annulment proceedings, the party will try to blow up the corruption allegations. New reports surface, new evidence surface. How do the French courts deal with this? Because there's also something as the finality of the arbitration, and annulment proceedings are not meant to be full appeal proceedings. So how do the French courts deal with these new facts that surface during annulment proceedings?
Thank you, Wouter, for the question. So let me talk about principles first. the French courts are very clear on the fact that when it comes to corruption, you can raise it at any time, and you can also rely on new evidence. So that's the principle. Okay. So normally, to answer your question, it would be pretty straightforward. Yes, you can rely on new evidence before the Court of Appeal, even evidence that has never been raised before the arbitrators. It's not very fair because normally you're supposed to put before the arbitrators and only before the arbitrators, because that's the whole point of arbitration. This evidence, nonetheless, we think the fight against corruption, well, I'm saying we, the French judges, of course, is more important and therefore enables the parties to raise new evidence. So that's for the principle. However, we see in some decisions that although it's not stated that clearly, there is some kind of, I'm not going to say shift because that's probably too strong, but there is some kind of adaptation whereby that principle is not applied that strictly. I have two decisions that come to mind. There's a first decision whereby the court doesn't come back on the principle, but says, hey, you could have raised that before the arbitrators, and why didn't you do so? Maybe it's because your evidence is not that strong. So, they didn't go against the principle, but the way they applied it seems that, by assessing the weight of the evidence, how strong it is, they kind of made a break into the principle I was referring to earlier. And then there is also, although it doesn't go for corruption, I don't per se, but in the Cardinal case, since you're familiar with it, the allegations were not allegations of corruptions, but they were allegations of fraud, and there were well, that's very strange because the Court of Appeal in Paris said this deals with private parties' interest. But if you look at the facts, it was fictitious invoices, and I think it was embezzlement of public funds. So fictitious parties, the fact that they lied in the tender, that was what was put before the Court of Appeal. And here again, the Court of Appeals normally you would have said, well, we're talking about fraud. It's the sovereign, the Central Bank of Iraq, potentially. So all this put together, you could imagine the court to say, well, I admit new evidence, and they didn't do so. They say, well, they made that strange distinction which didn't exist before, saying, well, you have it's l'ordre public international de fond, but when it comes to protecting private interest, then you have to raise everything before the arbitrators, so you're too late now, and I'm not going to look at this. And all the new evidence that you're putting forward, I just won't look at it, it's inadmissible. So I think there's a principle, but it would be very dangerous from a party perspective or from a counsel perspective to rely only on this principle and say, I'm safe, this is corruption, I can save it for later. I think that would be a very dangerous stance to take, and it goes back to what Jean was saying earlier. I mean, if there's a smell of corruption, well, you'd better, I think it would be way safer to address it before the arbitrators rather than wait to see in which direction goes the award and then go to the annulment stage.
Yes, if we have some time, may I maybe add on what you just said?
Master of time is on your left. Yeah, no, we're all
then
good.
I'll turn my back and I'll continue speaking.
I'm going to start pointing names if I don't have volunteer questions,
So yes, first on the question of the possibility to raise arguments regarding corruption at a later stage. In France, the relevant provision is Article 1466 of the Code of Civil Procedure that says that if the parties have failed knowingly and for no valid reason to raise any claims to raise any irregularity, that's the word used, during the arbitration, then they cannot in a timely manner, they cannot do that later, which has been interpreted as, I mean, the question, what is irregularity, right? It has been interpreted as irregularity being more general than procedural irregularity and covering anything that can form the object of a valid waiver of the parties. So when it comes to the merits of the case, perhaps certain illegalities, they can form the waiver of the parties. A party can say, yeah, I mean, you kind of lied to me and you overcharged me for something, but I waive it. So this can be covered, and I wonder if that is the distinction that the court accepted in the Cardinal decision. But I think that this is the kind of the difference, and I think that this test is not very original in comparative law. Model law provides also more or less for the same thing. In Greek law, specifically, we say that a waiver can only concern what the parties can validly waive, and therefore public policy is excluded. And I think that the English Arbitration Act, the article that sets out what is considered as waived, what are the challenges that are considered as waived if the parties do not raise them timely, does not include violations of public policy, which is also something that the parties cannot waive. So just to say that in terms of principle, it's not exceptional. The idea is that, yes, we are talking about efficiency and procedural fairness and procedural good faith, and on the other hand, like principles that are very, that are extraordinary. And I say that even though as an arbitrator, I find it very hard to have your award annulled for facts that you didn't even know at the time of the proceedings, right? Yes, and then on the Cardinal case, you may not wish to speak right now, but we are very interested to know what the allegations were. Because, yes, no, seriously, don't you? Because the court said that this is not really a violation of public policy, this is a construction contract. And what do we have there? We have what you say about Cardinal is that the contractor misrepresented the experience in the relevant field. It doesn't amount as fraud, no? We see it very often in construction cases, in the bidding process, that a subcontractor who had signed the contract was de facto excluded from participating in the contractual performance. We have seen certainly certain infrastructure projects where the reality of the construction does not necessarily reflect the contracts in terms of what party does what. Over-invoicing without surfacturation, without really knowing what lies behind it, and involving subcontractors which have not been authorized by the client, the employer. Again, I mean, this is not that surprising in terms, or if we read it, we don't say, oh my God, this is a violation of public policy. We say this is business as usual. But then, sorry.
Can I invite you to my next meeting with the French Parquet National Financier? Because they tend to consider that all these consultants that are hired without, forewarning, or we could go to DC to the World Bank.
I didn't talk about consultants.
Okay.
Sorry,
well,
it was not in my list.
I'm sorry, subcontractors was the word I will use next time. And quote this panel.
No, what I meant, and again, perhaps this is not really the case, but of course I would not be of much use to you in these discussions, because the idea, the situation that I have in mind is more a need comes, and there is, I don't know, we need someone in a construction to do a specific task, welding, and our welding company has left or whatever, cannot do that now, and we need a welder today, and therefore we employ a new welding company without going through the process of have the company authorized by the client, which if the client is a public entity can take a lot of time. But sorry, just to continue on that decision, then after giving these examples of what has been complained about, then in the list of complaints, we also have like money laundering, which does not obviously come from the list that I have given you, or identity theft, things like that. So personally, I'm at loss as to what has happened in that case. If you are happy to tell us now, I would be very eager. If not, it can be done at a later, during coffee break.
Okay, so we're going to stick around you during the coffee break to hear about the good news. I'm going to turn to the panelists for final remarks unless I have a question from someone else or a comment. Okay, so before we go to the drinks, oh yes, please.
I think this is going to be a very hypocritic question. This is going to be a bit of hypocritic question. I would say corruption involves two people, both the parties. So there could be a chance for one party to take an advantage of the corruption to dismiss the expropriation claims by the state. So are the courts handling this issue, or is it something like similar to the distinguishing the part of the corruption and not distinguishing and letting it go?
It's a fairness issue, right? It's like you're corrupt as well, but you're going to take advantage of being corrupt yourself to get off the hook and not pay. That happens, unfortunately, quite a lot. Yeah, but Maxime.
Well, I think we need to. Here we're talking about international arbitration, and the arbitrators, as Athina was confirming earlier, they pay a lot of attention to whether their award is going to be set aside. And in this respect, their only role is to ensure that the award that they would render would be enforceable. And so they're not trying to make sure, that one is punished, and that's not their role. And the French courts actually underline this many times in their decisions. They're saying, we're not going to look at whether there's been corruption from a criminal standpoint. This is not our role, and this is not the role of the arbitrators. So I think normally if everyone plays its role, we shouldn't have this kind of discussion, because normally you would have, if there are clear indices of corruption, you would expect in an ideal world, in a normal world, that you would have some criminal courts at one point being seized of the matter, and those criminal courts would make sure that the other party that is benefiting in the arbitration from the corruption allegations doesn't get away with it. Okay, so I think if you take it from that point of view, I think that the result that you get from arbitration does not sound that shocking.
So, unless anyone else has a comment or a question, okay, so it's time for not coffee, but maybe we can have a drink, or is it too early? Okay, super. Thank you so much.